Namaskar, I am Advocate Saurabh Kunal. Today we are going to discuss about the citizenship. Citizenship, a very hotly debated topic in India, and recently after the Citizenship Amendment Act uh, 2019, there was a huge protest across India, particularly in Delhi. So today we will discuss about the articles dealing with the citizenship under the Indian Constitution. Part 2 deals with the citizenship, and Article 5 to 11 particularly deals with the various aspects of citizenship and the law, the Indian Citizenship Act, which is called as the Citizenship Act 1955. We will also discuss about it, in which various aspects of acquiring the citizenship and the termination of citizenship has been dealt. We will also discuss about it, and we will also discuss the amendments, including the recent amendment in 2019, which led to a huge protest across India. So first, understand who are citizen, or what is the definition of the citizen. Citizenship is a status of a person recognized under law as being a legal member of a sovereign state or belonging to a nation. So certainly citizenship is a political membership which gives political and civil rights to a member. So that is why it is very important, because it gives political right means right to vote, and other civil rights through which it can claim other civil amenities if a person is residing in any country, particularly in India. So today we are discussing citizenship in context of India. So we will take example from India only. So the citizenship in India is governed by Part 2 of the Constitution of India according to Article 5. Now Article 5 says all those people who are residing in India at the time of commencement of the Constitution will automatically be the citizen of India. So it is very clear. All those people who are residing at the time of the commencement of the Constitution of India will automatically be a citizen of India. However, the citizenship in India is regulated by the Citizenship Act 1955, and time to time it has been amended to accommodate the aspirations. So the Citizenship Act has been amended in 1986, in 2003, in 2005, in 2015, and recently in 2019. In 1986, the Citizenship Act restricted citizenship to those persons who were claiming citizenship by birth, that one of the parents of the person who is claiming the citizenship should be from India. In 2003, it further restricted that one parent must be an Indian and other parent should not be an illegal migrant, particularly in context of the illegal migrants from Bangladesh. It restricted, and it also advised the government to construct a national register of citizenship. Now in 2019, the Modi Sarkar made an amendment, and it gave a liberal approach to the religiously persecuted minorities from our neighboring country who are in India, who are residing in India, to give them access to our citizenship. So it liberated, it became very liberal, and it made the path easy for those people who are religiously persecuted, and they are in India residing. They are forced to migrate to India, and they are residing in India without any civil and political rights. So to make their life easier in India, they amended. However, it led to a huge protest across India, and which is still going on in certain parts. So now let's discuss what are the articles which deals with the citizenship. So first, as we already know, that Article 5, citizenship at the commencement of the Constitution, which automatically grant the citizenship, the status of citizenship to all the people who are residing in India at the time of the commencement of the Constitution. Now from Article 6 to Article 8, it deals with the particular situation which arises at the time of partition. So to deal with the issues of citizenship, it has prescribed certain laws which has been under Article 6. Article 6 says that citizenship of certain person who have migrated from Pakistan. Article 7, citizenship of certain migrants to Pakistan. Article 8, citizenship of certain person of Indian origin residing outside India. So this article also deals with the rights of the people of Indian origin residing outside India for the purpose of employment, marriage and education. Now we will discuss Article 9. Article 9 of the Indian Constitution is very important as it gives a single citizenship in India. There is a confusion that whether in India there is a dual citizenship because of the Overseas Citizenship Act. No, I want to make it clear that in India the citizenship is single. Why it is single? Because if anybody who acquires the citizenship of any other country, his Indian citizenship will automatically be terminated. So that is why in India we have a single citizenship. Now Article 10. Article 10, any person who is considered a citizen of India under any provision of this part shall continue to be a citizen. Means any person in India who is residing, who is an Indian citizen, will remains to be an Indian citizen unless or until any law made by the Parliament of India. It means only Parliament can make law with regard to the citizenship. Now Article 11 says Parliament to regulate the rights of the citizenship by law. Means Parliament can only, again it is very clear that only the Parliament can enact any law regarding the citizenship. Now the Citizenship Act 1955, it is very important because under Article 11 the Indian Citizenship Act has been enacted, and the Citizenship Act 1955 deals with the way through which citizenship can be acquired in India, which are as follows. First, citizenship at the commencement of the Constitution. As we have discussed earlier, those who were residing in India at the time of the commencement of the Constitution automatically becomes the citizen of India. Second, citizenship by birth. So those individual whose parents are Indian will also be will be an Indian citizen. Now third, citizenship by descent. So here obviously for this there was amendment in 1986 that one person should be an Indian citizen and the other person should not be. In 2003 it was restricted that the other person should not be an illegal migrant. So this is by citizenship by descent. Another, citizenship by registration. For example, if an Indian citizen marries an foreigner, so after the marriage, if the spouse comes to India, so after registration he or she can become an Indian citizen. Now the fifth point for acquiring the citizenship of India is citizenship by naturalization. If anybody who is residing in India for more than 7 years can apply for citizenship of India through naturalization, means he is staying in India for last 7 years, so he can be an Indian citizen. He is eligible to be an Indian citizen. So this is the five ways. Now if India incorporates any territory, so it has to give the status of citizens to all the people who were residing or who are residing in that territory. For example, Goa was incorporated in Indian territory. Sikkim was incorporated in Indian territory. So those people who were residing in these territories automatically become the citizen of India. Now we will also discuss how it can be terminated. So first is renunciation. If anybody acquiring the citizenship, he can renounce his own Indian citizenship. Second is termination. Indian citizenship can be terminated if somebody voluntarily acquires the citizenship of any other country. And deprivation, the government of India has right to deprive the citizenship status of few people by an act. So these are the provisions for deprivation through renunciation, through termination, or through deprivation by an law. So these are the things. Now here two things are very important. People of Indian origin, sometimes, because we have already discussed about the Indian overseas citizen and citizen, in which we have also discussed that people of Indian origin, like we have a huge civilization and people have migrated from India across the world during various time, particularly during the colonial time. So those people who migrated from India during the colonial era, because of some bonded labor issue. So they can they have given the privileges to be to avail the various rights. And however, there are the people of Indian origin. In 2015, there was an amendment, and the people of Indian origin, the Prime Minister announced that the people of Indian origin, now they can apply for the overseas citizens of India to avail the various civil and political rights which were given to the overseas citizens of India. Now, coming to the more important issue, overseas citizens of India. The overseas citizens of India, particularly those people who are residing in America and European country, they are very demographically very rich, and they are very powerful group. So they were persistently demanding for the dual citizenship. So in 2005, the government of India came with a overseas citizenship India, which gives them various rights, particularly a lifetime visa. They have right to education. They can come here for multiple times. They can do the trade. They can establish industry. They have every right except one single right, which is the political right. So this Overseas Citizenship Act do not gives the political rights, particularly the right to vote. So this is the this is how we still in India we have the single citizenship, even though there is all the facilities which are availed by an Indian citizen can also be availed by those people who are getting the status of overseas citizens of India, but they don't have the right to vote. So this is the difference between the Indian citizenship and and overseas citizens of India. And the latest amendment we have also dealt. So this is all about the citizenship which is under Article 5 to 11 and the Citizenship Act. So I will be coming up again with another video on fundamental rights. So if you like my video, please like and comment your views, and please subscribe if you have not subscribed, because at this place we will discuss topics about the legal awareness and financial education. So please subscribe to my channel to get the latest update. Thank you very much for watching.